Welcome to Law Excellence Hindu News Analysis. Today we are going to cover these 6 topics that are appeared in the Hindu newspaper, right? Now coming to the first article. Now this article is saying that commissions for SCs, STs, OBCs, minorities discuss their common issues. Now what is the context of the news? The context of the news is recently the bodies such as National Commission for SC, ST, OBC, minorities, all these commissions conducted a meeting in which they are discussing the common issues that are faced by these bodies in addressing the issues of vulnerable sections. Okay, this is the context of the news. Now why these bodies are important? You know that certain bodies are established to look after the problems faced by the vulnerable sections, backward classes, etc., to handhold them in enabling their rights such as fundamental rights, okay, and suggesting the government in implementing the constitutional duties. Now this is the context of the news. What are the challenges that are faced or the common issues discussed in this conference? Now first of all, before going to discussion, now we'll relate to the syllabus first. In GS paper 2, it is clearly mentioned about syllabus topics, statutory and constitutional bodies and laws implementation mechanisms regarding vulnerable or weaker sections. In previously GS paper 2 also there are questions asked about National Commission for Backward Castes, National Commission for Backward Commission. Recently constitutional status also given through 102nd Constitutional Amendment Act to the National Commission for Backward Commission, right? And this was asked in GS paper 2 also. Now what are the functions and limitations of the National Commission for Scheduled Castes and Scheduled Tribes? These are the questions are asked in the GS paper 2, right? Now what are the challenges now we are discussing here can be used in the examination GS paper 2, right? The first and foremost challenge discussed in this conference was officials evading summons. Now certain times when any violation of fundamental rights done by the executive public authorities, these officials of these commissions will give notice to certain officers to someone, that means to attend before them to give their reply based on the complaints. But what happened? They generally reject that or don't attend. So because of the recommendatory nature, right? And another important thing is organizations refuse to follow the recommendations given by these commissions by getting stay orders. But for example, recently it has been said that TTD board in Andhra Pradesh also rejected a lot of directions by getting stay from the high courts, right? Now it is being said that, and like the similarly there are public sector organizations, banks also delaying the implementation of its recommendations in promotion appointments to the backward sections. Now these are the things mentioned in this article. Now these commissions are arguing that these commissions have a power of civil court. Now when there is a power of civil court, they have a power of adjudication. Now when there is adjudication, why Supreme Courts or High Courts or any other courts immediately staying the orders? They have to take the time and analyze the reasonability and rationality of the orders given by these commissions, right? Now this is what the arguments given by these commissions. Now you can use these challenges in questions asked in GS paper 2, right? Now in this conference they said that they are sending a memorandum to the central government to empower the commissions so that to enforce so that government should use certain amount of power to enforce their recommendation to certain extent. That means giving teeth to them, okay? These are the things mentioned in the article. Now coming to the prelims perspective, you have to know certain things because certain bodies are mentioned in this article. Statutory, see, in the article it is mentioned about National Commission for Minorities. Don't confuse that National Commission for Minority is a statutory body, okay? It is not a constitutional body. It was established under the National Commission for Minorities Act of 1992. Now next, a body mentioned here, it is National Commission for Safai Karmacharis. Now remember that it is not a statutory body nor it is a constitutional body. Earlier it was established through resolutions, okay? It is not a statutory body, remember this. Next, there are certain constitutional bodies mentioned in this. That is National Commission for Scheduled Tribes, National Commission for Scheduled Castes, National Commission for Backward Castes. Now remember this NCPC, it got constitutional status recently in 2018 with the 102nd Constitutional Amendment Act, okay? These are the things you have to remember from the prelims perspective especially, okay? Now coming to the next article. Now this article is saying that Supreme Court asks central government to file report on the Pennayar water sharing dispute. Now remember that if any question asks about Pennayar water sharing dispute is between which of the following states, remember this is between Tamil Nadu and Karnataka, okay? Now what is the issue is that this is an interstate river in which it is flowing from Karnataka to Tamil Nadu. Now recently what happened, Karnataka is conducting construction dams and diverting the water for its own needs. Now this is what questioned by the Tamil Nadu government because it is saying that it is affecting the needs and livelihoods of the riparian below states, riparian below people in the Tamil Nadu farmers. Now this is what the argument. Now they are saying that interstate river water is a national asset. Now you cannot arbitrarily construct the dams and reservoirs. Now this is what the argument of Tamil Nadu. Now the dispute went to the central government where it appointed a mediation committee. It given a certain report. Now Supreme Court asking that to give that report. What is the outcome? Now this is what the context of the news. Now from the examination perspective, you have to know certain things, especially both from prelims and mains perspective. Now in the mains perspective, you can use this as an example in the federalism, interstate disputes. Now how central can coordinate and cooperate central government, right? Now that is the way. Now from the prelims perspective, you have to know the rivers mentioned in the news are very important. Previously, rivers are asking in the examination continuously, either it may be tributaries or the river banks, popular places, something like that, okay? Now remember this Pennaya river or South Penna river is originating in the Nandi Hills in the Karnataka, okay? Now another important thing, UPSC sometimes asks that whether it is west flowing or east flowing river. It is an east flowing river emptying into the Bay of Bengal, okay? Now next, this is the second longest river in Tamil Nadu after Kaveri. Now another important fact about this river is that it flows through all three states such as Andhra Pradesh, Karnataka and Tamil Nadu. Mostly Karnataka and Tamil Nadu, a minor part in Andhra Pradesh also. Next, some of the constitutional provisions that we have to remember, especially in the context of the news. See, recently a negotiation committee was established between these two states by the central government. Why it is established? First of all, because as per the Article 262 of the Constitution, Parliament is empowered to control, use, distribution or control of water in the interstate rivers and river valleys. Now in this context, it enacted, because of this constituent power given to the Parliament, it enacted Interstate River Water Disputes Act of 1956, right? As per this act, central government can establish a committee, that is what the committee here, okay? Now why the Supreme Court involved? If any decision is not consensual or not accepted by any state, the state can directly go to Supreme Court. Why it can directly go to Supreme Court? Because it is Article 131 that gives powers. Article 131 provides for original jurisdiction of the Supreme Court, in which the dispute between the states or dispute between the state and central government can be directly adjudicated by the Supreme Court. That is Article 131. This is called original jurisdiction. That's why Supreme Court given the order. So if any dispute between any two states, the states cannot go to any high court, right? It has to directly go to Supreme Court. That is original jurisdiction. That means power to hear first instance. Okay, this is what the things you have to remember from the examination perspective, right? Another important thing mentioned is Markandeya Nadi river. Okay, this Markandeya Nadi river is a tributary of this Pennaya river. Okay, it is also flowing in the Karnataka. Just remember this fact. Okay, now coming to the next article. Now this article is saying that with RTI fading, Supreme Court asks government to fill up the vacancies in Central Information Commissions and State Information Commissions. Now what is the context of the news? Recently, Supreme Court taken a serious note that Central Information Commissioner, which is the top body established under the RTI Act for enforcing this act, has a lot of vacancies. Especially it is saying that there are 7 vacancies of the total 11 notified positions, right? Now not only that, this article is mentioning that there are a lot of vacancies at the state level, state information commissions also. Now it is being said that Karnataka has 8 vacancies. There is no even chief information commissioner at the state level also. Now Tamil Nadu has around 41,000 appeals are pending, and there are 2 vacancies in the state government. Now there are few vacancies in West Bengal, Odisha, things like that. So now this indicating that inefficiency in working of the Right to Information Act. Now this is the context of the news. Now how this is important for the examination? Yes, RTI is very important, especially from the GS paper 2 and GS paper 4. Now if you see previous year questions, especially every alternate year, there are questions about Right to Information Act, because Right to Information is very much important from the governance perspective. Now governance is a syllabus topic itself in the GS paper 2. Right? Now if you see previous year question, I have just taken example of one question, but there are many questions asked in the previous year questions, right? Especially mains. Now RTI Act is not all about citizens empowerment alone. It essentially redefines the concept of accountability discussed. Now this was asked in 2018. Now in this context, we will see certain provisions in the RTI Act and also certain challenges faced by it, especially from the mains perspective, right? Okay. From the prelims perspective, you have to know certain things, especially RTI is under the jurisdiction of Department of Personnel and Training under the Ministry of Personnel, Public Grievances and Pensions. Now this may be asked in the prelims examination. Remember this, right? UPSC has a habit of asking that whether this act replaces certain another act, right? Now remember that RTI Act 2005 replaced the Freedom of Information Act of 2002. Okay. Now there is a provision in the RTI Act, that is section 4, which is saying that government or public authorities should proactively disclose certain information to ensure trust and need not have formal request through RTI application. Okay. Now this is what to ensure transparency. Now this is one of the important provision. Though there is a criticism that this provision is not properly implementing. Okay. Now another thing. Now where it is applicable, right? The constitutional bodies, statutory bodies, or the bodies that are owned and controlled, substantially financed by the government. It can be non-statutory bodies also. It can be NGOs, but such NGOs has to be substantially financed directly, indirectly by the government. And remember that even political parties are also comes under the definition of public authorities. Okay, so you can get the information regarding public authorities also. Now next, there are certain exemptions that you cannot get information through RTI Act. That is majorly investigating bodies such as CBI, Intelligence Bureau, Research and Analysis Wing, Enforcement Directorate, National Technical Research Organization, CERTIN, and there are many others also. I think there are total 27 organizations that are exempted, right? Okay. Now there is a section 8 in which it is said that certain information is exempt from the disclosure if it is affecting the sovereignty, integrity, friendly relations with foreign countries, if it is any defaming, things like that. There are certain conditions. Okay. Now remember that when you apply to the RTI Act, you have to get information within 30 days. Or if you don't get it, or if you are not satisfied with the information you got, you can first applied body, you can apply through that. If you are not satisfied with that also, you can go to the State Information Commission, right? Next, if it is an issue of life and liberty, you must be getting information within 48 hours. Now these are the provisions that are mentioned in this article. Now there have been criticisms also that these provision of 48 hours is being very less implemented because of rejections, right? There is not properly organized data. Now another important thing you have to remember is that in 2019 there is an amendment happened in which it is said that central government will prescribe the terms, salaries, allowances of the information commissioners and chief information commissioners both at the central and state level. This is, remember, because many people think that at central level central government will decide. No, here in the state level also it is the central government which decide. Remember, this can be asked in the prelims examination. Okay. Now we will see from mains perspective certain analysis, especially about the challenges. Okay. Now what is first of all significance of the RTI Act? See, now you know that government is working for the public interest. Okay. Now they are the public servants, all the executives and all. Now through which what they are working? They are working through the revenue generated through the taxing the people. So it is public money using for public purposes, and there are schemes, welfare policies in which public has the right to know also. Okay. Even in Raj Narayan case, Supreme Court said that right to information is part of the fundamental rights of Article 19. That is, if there is information, it enables freedom of speech. Okay. In this context, it is very important. So in this context, it said that it empowers the citizens. For example, if there is an information for the citizen, they actively participate in the public discourse, discussions, debate. They can even question the government also why I am not getting certain policy or certain welfare scheme. Right? Okay. Next, transparency. Now it is being said that in section 4, you have to proactively disclose certain things. Now this improves the trust of the people on the governance system. Right? Next, accountability. For example, NGOs, civil societies, pressure groups are using this RTI tool, social activists, to question the government. This creates a deterrence, especially among the officers, to behave arbitrarily. Right? This prevents arbitrary behavior. Next, expose corruption. For example, if any construction or happened, allocation of money. Now RTI can question how much money is allocated, how much is spent, and how you are spending, or how the project is allocated, whether based on the merit basis or based on the favorable basis. Now things like that, this lead to exposure of corruption. There is an example that others housing scam which is exposed using RTI Act also, right? Effective implementation of policies and welfare schemes. Now you may have heard that in Rajasthan, MG Narega frauds were uncovered, especially using the RTI Act. Okay. Now from then it leads to strict implementation and overlook or monitoring on the schemes, right? Now this is the significance of the RTI Act. Next, what can be the challenges? The first and foremost challenge is functional issues. Now, just now in this article itself, it is mentioned that many of the information commissions at the state level are defunct, especially in states like Jharkhand. And there are many vacancies. Just now, it is there vacancies at the central level also, Central Information Commission, right? Now next, inordinate delays. Now we have seen that we have to get information within 30 days or 40 48 hours, right? Now it is being said that there are many commissions taking more than 1 year. Now people get less interest or less confidence on these institutions, right? Now there are issues of backlog, especially past cases. Now it is being said that across India there are around 4 lakh appeals that are pending across 29 commissions. That means 29 states and union territories, something like that. Okay. Next, there is lack of proper interdepartmental coordination. Now why it is being said that? It is said that around 42% of the RTI appeals are rejecting. Why they are rejecting? They are saying that this not belongs to our department, so you have to apply to that department, and in this way they are rejecting. Now the interest of appealing to the citizen will be reduced by this of rejections, right? Now this indicating that there is a lack of interdepartmental coordination. Next, skewed gender composition. What does it mean? Now it is being said that only 9% of the information commission or employees working under the RTI sector are 9% are only women, remaining are men. Next important thing is structural issues. What does it mean? Now there are certain bodies which are exempted, authorities lying outside, but this indicating lack of transparency of spending of money. For example, it has been said that PM Cares Fund is being criticized for this, right? Next, dilution through amendments. Recently in 2019 amendment, now it is the central government that is deciding salary allowances and conditions. Now this affects the independent functioning, right? Now this is what the criticism. Now there are certain procedural issues, right? That bureaucratic resistance. What does it mean? Now for example, if a certain department, if there is any corruption or wrongdoing is uncovered, now it is a bad to the entire department, so most probably they won't disclose such information. They avoid or try to look after the ways to avoid RTI appeals, right? Non-compliance. Now it is being said that as per the provisions, now organization has to have public information officer, but certain organizations and departments it is seen that there is no public information officer in such departments. Okay. Next, lack of awareness. What does it mean? Now it is being said that only 25 to 35% of the people have awareness about usage of RTI. That means it leads to underutilization. Okay, that is what the thing. Now another important thing is contradiction with official secrets, in which it is saying that certain information is considered as classified and important from the national security perspective. Now in this way it has broader interpretation, right? Now every information can be classified, right? We have arguments. Now things like that, there is an inadequate training of the PIOs, public information officers, and people are feeling that they are indifferent to the people who are applying the RTI. Now this is what the criticism. Okay. Now coming to the next article. Now you can use all these things points in the GS paper 2 mains examination. Okay, take a note of these points. These are just keywords, important keywords. Okay. Now coming to the next article. Now what this article is saying? Now this article is saying that between hope and hurdles on the high seas. Now what is this high seas? Remember that the region beyond the exclusive economic zone is called high seas. Okay. Now remember this classification given by the UN clause. It's a territorial sea, means from the baseline it is 12 nautical meters. Now this is important knowing this difference, because recently in prelims POQ it was asked that what is the area constituted under the territorial sea, exclusive economic zone, things like that. Okay. Next, contiguous zone means 12 nautical miles from this territorial sea, and exclusive economic zone is about 200 nautical miles from the baseline. Okay, remember these facts. Now what is this article is saying? This article is saying that if there is within the exclusive economic zone, countries are managing them, conserving them, utilizing them in a sustainable manner. Okay, but beyond this exclusive economic zone, who will regulate, who will conserve, who will control the mismanagement, illegal fishing, illegal activities? Now this is the context of the news. Now recently what happened? Biodiversity beyond the national jurisdiction. Biodiversity beyond national jurisdiction. Now this is a treaty under the UN clause. For what? To conserve, manage, sustainable, utilize the resources of the high seas. Okay, this is what the treaty. Now this is also called as high seas treaty. Okay. Now this is under the UN clause. Now from the prelims perspective, you have to know certain things. Especially in mains, there is previous question asked about what is the role of International Maritime Organization in controlling, preserving and conserving the biological diversity, especially marine diversity. Okay. Now in this context, knowing about this treaty is also very important. From the prelims perspective, just remember the fact that this high seas treaty has been signed by India, but not ratified. Remember, but not ratified. What is the difference? Ratifying means it's something about you have to enact a permanent law, right? Okay. Sign means just execute. That is president is signing. Okay. Now we'll see from the main perspective certain points. Okay. Now, what are the objectives of this treaty? There are main three objectives. Remember, there are three objectives. Conserving the marine biodiversity. This is very important. What is marine diversity? There are coral reefs, right? seagrass bed, things like that. Now it is also considered as underwater tropical forest. Okay, and these have more number of animal phyla than tropical forest on the land itself. In this way, there is a lot of marine biodiversity that are unfound anywhere else. Next, equitable sharing of benefits from the marine genetic resources. Now there is a lot of research happening, especially regarding marine genetic resources. Now, but this research is mainly done by the developed countries. Now the benefits out of it should be equally shared among the developing countries also. Okay, through knowledge sharing mechanism. Now this is what one of the important objective. Next, mandating environmental impact assessment for harmful activities. What does it mean? Now there are many exploitation activities happening in the marine areas, especially oil extraction, deep sea mining, okay, tourism, trade, etc. All these things are happening. Now, while conducting any of these activities, you have to do environmental impact assessment before conducting such activities. Now, these are the objectives that are mentioned, but there are certain other goals also mentioned apart from these three objectives. That is, conserving the marine genetic resources. That is, it is saying that we need to establish a global fund in which these benefits of marine genetic resources can be used for the developing, least developed, and small island nations also. Now next, equitable partnership in ocean science. Now it is said that the research and development, that is R&D capacity, is mostly with the developed countries because they have the capital to fund the research activities, right? Now the outcomes of this research and technology transfer should be transferred to the developing countries also. Now this is what the things that are mentioned in this article. Now remember certain things from the examination perspective. This treaty, High Seas Treaty, is legally binding. Now UPSC has a habit of that whether a particular convention or conference is legally binding or not. Okay, this is legally binding. Next, this treaty entered into force 120 days after the 60th country ratification. Now presently it has been said that only 14 out of 104 signatories are ratified. It said that it needs 60 countries to be ratified to come into force, but presently it has only 14. So hence it is not come into force. Okay. That is a fact, remember. Okay. Next, there are certain challenges that author mentioned for this treaty. Now, what can be the challenges? There is a lack of proper, clear implementation roadmap. Now, the treaty is mentioned objectives, okay, resolutions, but there is no clear mechanism who will implement this because this is high seas, okay. There is no one have a proper national jurisdiction who will implement this properly. Even this treaty is also under the UN clause, but UN clause don't have a proper mechanism unless and until there is a cooperation from the coastal countries. That is what mentioned in this article. Next, important thing is just now we mentioned that only 14 of the signatories are signed and ratified. Okay. Next important thing is disputes over maritime territories. Why? See, high seas, there is no jurisdiction. Now there are maritime disputes in South China Sea. Okay. Even in the Indian Ocean also we have Kavadiguda Island dispute. Now things like that. So when there is disputes like this, how they can coordinate and cooperate in conserving the marine resources? Okay. Now there is an issue like this. Next, there are overlapping claims complicate the consensus. For example, if they want to conserve particular area by declaring a marine protected areas. Now under this conference or convention, there is a provision that to declare marine protected areas, to conserve them, to conserve marine resources. But to conserve, there is a coordinated activities from between the nations, right? Now for that, this coordination is very difficult to get a consensus on a particular decision because there is a overlapping claims. For example, I mentioned that India and Sri Lanka or Kavadiguda Island itself. Okay. That is, next, limited economic opportunities for coastal communities. What does it mean? See, by declaring an area as a marine protected areas, it limits the economic activities of the coastal communities, especially fishermen communities who live their livelihood based on the marine resources. Now, by declaring such areas creates restrictions and regulations. This may restrict their economic opportunities. Now, this is what one of the apprehension. Next, underreporting their activities. What does it mean? Now, recently there are a lot of unregulated fishing, unregulated deep sea mining is happening now within the exclusive economic zone. Now these activities within the exclusive economic zone can have spillover effect on the high seas areas, but these things are not notifying properly, underreporting by the countries. Now this is what one of the news, and the recent best example is express PL disaster happened in the Sri Lanka, which spilled hazardous chemicals into the Indian Ocean. Okay, things like that are happening. Next, capacity building, technology transfer. See, to conserve the marine resources, we need technology transfer, especially small island nation doesn't have such resources, especially in terms of capital and technology. But these are not transferring. You have seen in the climate change conferences itself, developed countries are reluctant in transferring the money, capital, climate finance, even technology as well. Now, how this can be happened at the ocean marine level? This is what the author's argument. Now, another thing, important thing is there is overfishing happening within the exclusive economic zone, especially in the West Africa. This limited the existing stocks of the fish, which is far beyond the national jurisdictions. Now, this article author mentioned that we need to conserve the first of all marine resources within the exclusive economic zones also first of all. Then we have to think about high seas. Next, there is another criticism about this convention is that this convention is silent on the damaging harms during oil and gas exploration activities. Now, this lead to often oil spills in the ocean areas. Now, this lead to dead zones. Okay. Now, this convention is silent on these issues. Another important criticism is that now who will do this environmental impact assessment? Now, there is no mechanism, there is no body that who will do this EIA, environment impact assessment. Now, these are what the challenges mentioned in this article. Okay. Now, the article mentions certain suggestions that there are many conferences happening regarding global greenhouse gases, climate change, and all these things. There are a lot of ambitious targets given, but there is no action at the ground level. This type of convention may also fall prey to such a type of activities. Now, next, there is a need of reconciling the high seas governance with coastal regulation, because as I seen that most of the role to conserve these marine resources is with the coastal states. Now, coastal states has to align their policies, especially marine policies, with the international laws, and they have to provide technical and financial assistance, especially from the developed countries. Now, next, there is a need of enforceable mechanisms to ensure compliance. Now, this is what they mentioned in this article. You can use this in GS paper 2. If any international organization question, especially regarding marine resources came, you can use this, right? Even not here in GS paper 3, there are questions asking about marine biodiversity, conservation of coastal areas. Even there also you can use this high seas treaty and some of the points mentioned here. Okay. Now, coming to the next article. Now, this article is saying that milk, meat and egg production increased recently. Now, what is the context of this? Now, there is recently an increase in production seen in terms of the milk, meat and eggs production. Now, milk production is increased around 4%. Okay. Now, this is important especially from the prelims perspective. Mainly you can use in GS paper 3, especially in the syllabus topic of agriculture. Now, these things, poultry, meat and milk, all this comes under the secondary agriculture, which is very important to increase the farmers' income. Now, you can use these facts as an examples in the JS paper 3 question. Now, certain facts, just keep remember that India is the largest producer of the milk. Okay. Now, India is the second largest producer of the eggs. Now, within the milk, it is the UP that is the largest state in India in production of milk. Next, Rajasthan. Next, in eggs in India, it is the Andhra Pradesh that is the largest producer of eggs. Now, it is said that among the meat exports, there is increase in production of the meats. Now, within the meats, it is the poultry that constitutes 48% of total meat production among all those things. Okay, and after that it is buffalo 18%, and after that it is goat 15%. Now, remember these facts sometimes. Okay, you can use in the mains examination. Okay. Now, coming to the next article. Now, this article is saying that from a republic to a republic of unequals. Now, what is the context of the news? This article is saying that recently November 26, 2024 constitutes 75 years of adoption of constitution. Now, in this context, the article is saying that constitution has a goal of establishing egalitarian society. Now, what is meant by egalitarian society? Having equal opportunities, having social equality, less status differences, etc. Ensuring social justice. All these things are part of the egalitarian society. Now, these things are codified and mentioned in the directive principles of state policy. Now, it is clearly mentioned in Article 38 itself in DPSP. There is obligation on the state to minimize the economic inequalities, elimination of status differences, providing the opportunities. Now, by providing opportunities, you can minimize the economic inequalities and hence you can eliminate the status differences. Now, this is what one of the goal. Now, next, in the Article 39 itself, it is mentioned that the resources of the society should be used in a way that should serve the common good. Economic system should work in a way that to prevent the concentration of the wealth. Now, this indicating, but the author is saying that India, there is a lot of economic inequality. Now, this is against the constitutional goal of egalitarian society. Now, that is what mentioned in this article. Now, this economic inequality has many reasons. Now, it is being said that one of the important reason is liberalization. Now, it has been said that due to liberalization, the state withdrawn its role in the welfare. Now, state is busy in strengthening the market so that it will be a favorable destination for the private investments. Now, this is what the author is saying. Author mentioned very important, interesting point is that social inequality and economic inequality has nexus. What does it mean? Now, it is been said that the upper caste are majorly rich. Now it is being said that 90% of the billionaires or constitutes the upper caste. Only 10% of the OBCs constitutes the billionaires and only 2% of the scheduled caste. And there is no scheduled tribe representation in the billionaires. Now to substantiate his point, he said that around 1980s, top 1% are earning around 6 to 8% of the national wealth or national income. Now it is been said that after liberalization, that is around 2023, 1% is earning 40% of the income. Now this indicating that increasing economic inequality. Now this can be further substantiated by his argument that around only 10% of the people are earning around monthly average income of 25,000. Now the remaining 90% is earning less than 25,000. Now that is what the article. Now other also mentioned about meager incomes of the rural areas, especially the farmers. Now it is mentioned that in the agriculture census of the Nagar, that farmers are earning only around 10,000 per month, 10,800 per month. Now this indicating the dismal condition of the poor people in India. Now these are what the saying. Now other is saying that the goal of egalitarian society is far from reach. So in the process of becoming over rich or emerging economy, state should not forget its role of welfare. Now this is what this article is saying. Okay, you can use this article in GS paper 3. Now in GS paper 3, previously a question asking about, in the system of capitalist system, is it possible to achieve inclusive growth? Now this is what the question asked in the mains examination of GS paper 3. Now in questions like that, you can use this, right? Okay, that's all for today. Thank you.